There are three different and distinct types of plea agreements in the state of Indiana. Hi, my name is Corey Scott, and I am a criminal defense attorney here in Indianapolis, Indiana. Been practicing for almost 20 years. And I want to just tell you about the different types of plea agreements that we have here in the state of Indiana. And really, this applies to most states, to be honest. So, the first type of plea agreement is what is called a set term plea agreement. A set term plea agreement. And what this simply means is this is an agreement between the defendant and the state of Indiana where all of the terms, all of the particulars are laid out in great details so that once all of the parties sign off on it and once the judge actually accepts it, all of the parties know exactly what the sentence will be. So how long will the sentence be? Will the sentence involve prison time or not? Will the person have to be on probation or not? Is there a certain amount of court costs and fines that the person will have to do? Are there other special terms that they'll have to do? Do they have to take classes or counseling? Do they have to take drug screens, etc.? Everything is laid out, so there's nothing left for the judge to decide. The judge either has to accept it as it is or reject it. But if the judge accepts it, then the judge accepts all of those terms. Now, the second type is what I would call a partial set term plea. And it simply means that no, not every term has been agreed upon, not every term is laid out, but there are some of the terms are set out, and then there's other terms that are left to the court to describe, to put in place, okay? And so that means that you may have, let's just say that there are 10 different terms. And so maybe 7 of those terms are agreed to. Everything's laid out for 7 of those things, but you have 3 other things where, essentially the parties are saying, we couldn't agree upon everything. So, Your Honor, we're going to leave these other 3 things. We're going to make arguments. You can hear from both sides, and then you fill in a blank for these last 3 issues that remain. So that's a partial set term agreement. And then finally, we have what's called an open plea to the court. Now, an open plea means that the parties couldn't reach an agreement. The parties couldn't come to an agreement. So when the parties can't come to an agreement, the defendant can say, you know what? This prosecutor is being too hard. They're being too harsh. We can't come to terms. So, Your Honor, I'm going to plead guilty and I'm going to leave the entire sentence in your hand. And what happens in that situation is both sides, again, will argue to the judge. Of course, defense is going to be arguing for leniency. The state is going to be arguing for whatever they think is appropriate and right. And then after hearing from the parties, the judge will fill in all of the blanks and the judge will fashion a sentence that he or she believes is just and right and appropriate based upon whatever the convictions are. I really hope that this video has been helpful. Listen, if you have any questions, feel free to call me, email me, hit me up. I'd be more than happy to be of help. And until the next time, just remember, if you have to be guilty of anything, be guilty of greatness. Take great care.